Mr. Mikali, you dealt with SGS and Contacna cases on behalf of the Pakistani government until 2008. Could you please tell us at what stages were the proceedings when the mutual legal assistance was withdrawn?
Our firm has represented Pakistan from 1997 up to 2008, to my recollection. And in 2008, we were instructed on behalf of the government to withdraw and take the measures necessary to stop the proceedings. We did so.
I know you are aware that Pakistan's Supreme Court has asked the Prime Minister of Pakistan to write to the competent Swiss authorities to reopen the alleged corruption charges against President Asif Ali Zardari. Could you please tell us what should be the contents of such a letter?
I have seen general information about this in the press. You must be aware that there are two types of proceeding which were conducted in Switzerland. One is a Swiss penal proceeding where the Swiss penal authorities were carrying their own investigation for their own purposes. And another type of proceeding is a so-called mutual legal assistance proceeding. In that second type of proceeding, the Swiss authorities provide assistance to Pakistan to carry out the Pakistani penal proceeding. This assistance can be supplying bank records, freezing assets, hearing of witnesses, and so on. But the goal of this second type of proceeding is that the Swiss authorities supply Pakistan with what is needed so that the Pakistani penal authorities can conduct their own penal proceeding. Now, your question addresses two issues. What would be required for the Swiss to carry out their own penal investigation? That's one thing. And what would be required for the Swiss to grant further assistance to Pakistan?
Under mutual legal assistance.
Under mutual legal assistance, that's accurate. On the first point, that's the local Swiss penal proceeding, it is legally relatively complex. The facts lie back relatively far. We may have an issue of immunity, and there is also a question of opportuneness for the Swiss penal authorities to take that matter at hand. The situation is significantly simpler for mutual legal assistance. For that second type of proceeding, what the Pakistani authorities must do is file a request to Switzerland to know what has happened to the assets which had been frozen after 2008.
Are you suggesting that if Pakistan writes just this simple line of what happened to the assets that were frozen before 2008, can the cases then as simply be reopened?
Of course, it is not a two-line letter, but it is quite simple to do. What is required is that Pakistani penal authorities actively investigate and prosecute the concerned cases. And if that's fulfilled, Switzerland will help Pakistan and supply its assistance. That's the basic requirement.
What happens if Pakistan withdraws immunity, the presidential immunity? Will the Swiss authorities then start the cases from where they were left?
If Pakistan lifts this immunity, then Switzerland will go by what Pakistan has decided. If Pakistan does not recognize immunity to its head of state or to its public officials or former public officials, Switzerland will not either.
files related to the corruption charges against President Zardari were removed from your this very office near the end of 2008. So I just would like to ask you, do you have the copies of those bundles of evidence, and for how long are you bound to archive them or keep them in your records? And do you have the same bundle of evidence that the Geneva's prosecutor has?
As attorneys, we have a legal obligation of keeping at least a copy of what we have done for our clients. And of course, our firm has complied with this obligation. Our obligation is to keep records for 10 years after the closing of a case. The Prosecutor General of Geneva, who was dealing with the penal cases, also keeps his records for a long duration too.
Is there a certain time period?
I believe the time period is until the period of limitation is reached.
Which is?
15 years for the offenses of aggravated money laundering, which are the concerned offenses.
So that again brings us to the same question, which is the question of statutory limitation, the cutoff date, if I say it simply. So in the case of Pakistani President Asif Ali Zardari, what does the statutory limitation mean, and where does it start from and where does it end?
Period of limitation for the offenses which were prosecuted in Switzerland and judged in Switzerland is 15 years. 15 years counting from when? It is from the moment the offense stopped. And money laundering, when does that stop? When the last transfer took place.
And that was in?
We know of transfers up to 1997. We do not know what happened to the concerned assets after our firm stopped representing the government of Pakistan. We do not know that. We think there may have been further transfers.
Do you have any idea what happened to the $65 million unfrozen in 2008? Is there any trail or any idea of what happened to that money? And what if Pakistan lays a claim to that amount? I mean, how will it work out?
Our firm represented the state of Pakistan up to 2008. And of course, we remain bound by duty to professional secrecy even after that. So I can only speak about what has been rendered public, plus general information on Swiss law. That being, we do not know from publicly available sources what happened to the frozen monies after we stopped to defend the state of Pakistan. However, if I may add, if there have been money transfers, these transfers are certainly evidenced by bank records. Under the Financial Action Task Force rules, which Switzerland applies, all international bank transfers must be duly recorded, and it is certainly easy to trace the money if it has been forwarded elsewhere after 2008.
So if the cases are opened in Swiss again, whether it is under mutual legal assistance or under the local penal court system, if the cases are reopened, then will the Swiss authorities take the action to actually speak to the other competent banks to in terms of explain whatever happened to the money that was transferred to those accounts? I mean, what will be the level of participation of Swiss authorities?
Of course, if the Swiss cases are reopened, the first thing that the Swiss authorities will do is they will liaise with the bank to determine where the assets went, and if these assets are still in Switzerland, it is highly likely that they will be frozen.